Well, welcome to Hot Topics in the Workplace, when medical conditions impact the ability to work. So welcome, everyone. I'm Dr. Debra IPM facilitator, host, and founder of Hot Topics in the Workplace. And with me is my co-founder, Felicia Menta from, Felicia, you say your title.
Senior Manager of the Workers' Compensation Program for the San Diego County Schools, JPA. Happy New Year, Deborah.
Well, Happy New Year to you too, Felicia. You know, I don't know if our listeners and the people we work with know just how far we go back, but I just want a little tidbit now that we're in the new year. And we actually go back to the early 90s when you were doing a claims job and I was doing voc rehab, and, you know, our connection has continued throughout the years, and then the whole development of the IPM process. And as it were, in 2017, here we are working together once again.
It's such a pleasure for me.
Well, thank you. There's definitely a pleasure for me as well, because, you know, it's important to have, it's important to challenge mindsets, but it's also important to connect with people who have like-minded mindsets in terms of how we treat people. And we are people, no matter where we are, but we're talking about people who are employees when medical conditions impact their lives. And I like to emphasize that, you know, we're all just people, and we're all going to have a medical condition at some point in our lives that may majorly or minimally impact our lives and our ability to work. And I know my first experience actually went way back to my dad when I was growing up. I realized that after many years, like, oh, how did I get involved in this field? And I realized my own dad went through it. And then when I had my first pregnancy, I had complications, had to go out of work. And so I realized what it's like to be off of work due to medical condition and being unable to do much of anything. So, Felicia, I'm sort of curious, you know, just to let our listeners know, how did you get involved in this kind of work?
My neighbor was the claims supervisor for Paramount Studios workers' compensation claims, and they were self-insured. And she is the one who asked me to come and apply to work for them. And I started, she said, you're going to start at the bottom and work your way up as a claims assistant and work your way all the way through. But that is how I got into the business, because of my neighbor. And she was sharp and tough. So I was trained well from the very beginning.
Well, wonderful, because I mean that shows the power of a sort of a mentor in a way, somebody you admire or relate to, and you can lead you into a whole direction. Yeah. And so I'm sort of, when I look back, I go, wow, I can't believe my entire career has been centered around this, although I've done many other things, but I keep coming back to this because, again, medical conditions are all going to impact us at some point in our life, to either yourself or to others. And certainly we know people right now struggling with what's going on in Southern California, the fires and so forth. And so we all probably know somebody who's been touched.
Yes.
So our agenda today, folks, is fourfold. So first of all, we want to talk about that long COVID pushback. You know, where are we? It's 2024, that started in 2020. And sometimes it feels so far away, and yet it's still close because we're still having COVID issues. And so we're going to talk about what happened, what are the lingering effects, and what's some of the pushback. And then another topic we came up with, and some of this relates more to the cases we see locally. You know, you settled the workers' comp case. Now what? You know, how does that, impact how you manage this employee in the workplace? And then also, the compliance issues under workers' comp, but then also that big umbrella, the Americans with Disabilities Act and the California Fair Employment Housing Act, because after all, those are the real drivers of the IPM process. And so it's really important to identify and work with the different facets of an employee's medical condition. Our third topic is planning ahead. Who's on? Who's off? Sort of like baseball in a way. Who's on first, et cetera. But, who's on and who's off work. And we talked about this, at the beginning of the school year, Felicia, as far as, sort of reviewing things, getting ready for the year, not getting, caught off guard, sidestepped or sideswiped, I should say, by somebody's new condition, or maybe a lingering condition you may have forgotten about. And so in that regard, what are some things that we can do to prepare for, particularly now in January, as we look at the July 1st rollover? And we'll get into the details of that one, folks. Don't go away. And then what happens when accommodation requests are denied? And so Felicia found this interesting article, and how it's interesting is that employees are willing to disclose their disability, but not necessarily seek accommodation. What's that look like, and what does that mean? And this is driven by some of what EEOC is taking a look at in terms of patterns of accommodations, workplace complaints, and all that kind of stuff. And so I think these are going to be pretty rich topics, so a good way to start off our year. How about you, Felicia?
Oh, I agree. I found some really interesting articles.
Yeah. And so I want to just remind everybody that each month we literally talk about hot topics. We plan this out about a week or 10 days ahead of time so that we are truly current, in particular some of the cases that we might be dealing with locally and anonymously. I'll assure you, maybe yours, but we're not going to say who it is. But because it's relevant learning, and this is how we all learn. And I know, Felicia, you and I talked before, and I've certainly shared with many of the districts and cities I work with that, I've been in this field since, well, technically, book rehab. Okay, I'm going to date myself. I know it. 1982. And then with the ADA coming out in 1990, and things went, and then things sort of evolved in 2008, another big change for temporary versus, long-term accommodations. But, pretty not stagnant, but static, not a whole lot of change, so to speak. Continuing to clarify the laws around us at both the state and federal level. But boy, did 2020 bring about a whole new plethora of medical conditions that we never thought we'd be dealing with, but we are. And this is where we get into, is any medical condition and how we might be impacted. So openness, curiosity, and flexibility is really key.
Mm-hmm.
Talk about keeping employees at work for both their health and well-being and economic security, but also your health and well-being as an organization. So, Felicia, let's jump into the long COVID pushback. And we have an article that we'll share the link with everybody when we do the post delivery of the recording. And what's this article really talk about?
It's so interesting. The article started with long COVID can be considered a disability under the Americans with Disabilities Act. So that was sort of the banner at the top. And then they talked a lot about that employees were having their accommodation requests rejected, and also were struggling to afford medical care and take time off work, being able to take time off work to get treatment for their disability. You could really, we're going to talk about long COVID, but you and I know we can use all of this information with any chronic medical condition like MS or cancer or anything that's chronic, lingering, affecting an employee. They also talked about many of the employees with long COVID saw a real lack of employer support. And that's what grabbed my attention to use this as a teaching moment. Workers say that a number of the symptoms that affected their ability to work with long COVID were the things we know about, right? Brain fog, fatigue, overall weakness, headaches, and migraines, which we see on other non-industrial requests for accommodation all the time, right? Some of the employees said that long COVID led to changes in their employment status. Either they got laid off because they weren't able to do the job, or they got fired, or they couldn't because they couldn't perform their work. And that the employees said they struggled to both work and attend healthcare appointments to get better due to the time that it took away from work, and also the energy that it took to go do all these things. Because again, if you have fatigue and weakness, right, and brain fog, these things would be difficult. Some employees said they were unable to return to work, or they had to switch to lower paying jobs because of their chronic condition, or limit their work hours. And for many of them, their lives were completely changed because of the chronic medical condition. Some of the employees felt comfortable sharing the long COVID with their employer, but many of the employees in this article feared retaliation at work, and because some were afraid of being terminated. Workers reported resistance from their employers and lack of support for their accommodation requests. Some of those accommodation requests were things we see all the time, needing to take rest breaks. How often do we see notes about that? Need to take a 15-minute break every hour. Note taking. We see this in neurodivergence and other types of disability where that's where that brain fog and difficulty in concentrating, that they need to take notes so they can recall priorities. Another thing they said that employers didn't want to do was shifting hours and moving their shift around to accommodate some of these things. And then, of course, the big one, requests to work remotely or a hybrid, big one where they got complete resistance. Jan was talking in this article, and one of their executives were saying that employers should always err on the side of finding accommodation. Rather than focusing so much on whether long COVID or a chronic condition did or did not meet the definition of a disability under the ADA, he said we really should be leaning into trying to see how we can accommodate rather than more of a stiff arm approach. And so I just thought the article was interesting. Certainly it was written to apply to long COVID, but it could apply to any chronic medical condition where an employee is really struggling.
Yeah. Thanks, Felicia, for identifying this article, because I really, like you said, it's got application to many other medical conditions. And there are at least 3 points I want to bring up right now. Is that one, it's always, I can't emphasize that enough, always important to say, wait a minute, is this a short-term accommodation or a long-term accommodation? And for those of you out there, I hope that you recognize the short-term accommodation process generally is dealing with 60 days plus 60 days. You go ahead and implement a temporary accommodation for 60 days, see if the condition improves, what factors are, contributing to a non-improvement. And if it's not working, then you discontinue it. But if the employer is showing improvement, then we have the latitude to implement another 60 days for a maximum of 120. Now, keep in mind, that's oftentimes what happens at the local level, but at the federal level, it's up to 180 days for temporary accommodation. So that's number one question. Is this temporary or long-term? And so if it's temporary, work with it, because being at work is actually better for the employee most of the time, not all the time. Most of the time, it's better for the organization. So what's an adjustment for 30 days, 60 days, maybe even 90 or 120 days? It's when it goes beyond 180 days that starts to prove a hardship. And so keep that in mind. The second thing is that, and I think we see this in a lot of medical conditions, there's some disbelief on the part of employers per se, about is this real, or not? And so that oftentimes applies to things that we cannot see. So if we don't have documentation that's actually a work-related injury, for example, where we know there was a broken foot or, a rotator cuff tear or something like that. But when it gets to psychological, conditions like stress and other aspects, as well as whether it's work-related or not, as well as now COVID, those are not visible symptoms that you can see. It's what the employee, feels and reports. And so I think there's probably a lot of fear around being disbelieved, and then their character being questioned or judged. So I think that's another factor. And then thirdly is that, again, we're all humans. And so we're all going to have something, and maybe even our administrators, maybe our, top executives have been affected by COVID, foggy brain, for example. And that comes from other conditions, not just COVID.
Right.
Yeah. And so again, is this temporary or long-term? And if a person's seeking treatment, trying to get, involved in it, that's one of the real key things that drives the Job Accommodation Network, or JAN, as you refer to it, in the EEOC, is that, okay, what is the employer trying to do to understand the implications of this condition and how it impacts both temporarily or long-term? And so we have some parameters around, again, evaluating short-term accommodations. And then if it's not working, then that's when you consider what are the long-term implications. And that might be where somebody does have to separate from their job. It might be where they're no longer able to perform the essential functions of their job. We don't know that until we try something.
Right.
Yeah. Yeah, so this is unfortunately something we continue to deal with as far as the post-COVID long-term elements of this, and it's not to say, well, who knows with the norovirus that's out there, who knows where all this will be going, but yeah. Any other thoughts, Felicia, from what you've seen in cases?
Yeah, I mean, we have not a ton, right? But we had a certain percentage of our teachers and classified employees, both young and old, that got long COVID. And it's 2025 and they still have long COVID. And they got COVID in 2020 or 2021. That's when most of these people were exposed. And from a work comp claim perspective, they're very difficult to treat. We didn't know, the physicians didn't know very much about how the virus affected the body in the first place. And then a lot of the treatments weren't very effective. A lot of the people had inhalers, they had physical therapy to help with the weakness. The brain fog seemed to get better with some people with time. Time actually was the thing that helped some people. But a lot of our teachers that had long COVID were never able to get up to the stamina and the energy level that they had before. And some of them either had to switch into less arduous positions or ended up, going off work. You're right.
Yeah.
On long-term disability. So we really struggled. We couldn't understand in the beginning why we couldn't treat them and get them better. It just wasn't working like that. And even some of them were 40. They weren't all, we had some elderly, some of them were younger. And also,
well, watch what you call elderly, okay? I mean, that has different connotations. I'm sorry, I interjected, but our terminology is very important.
Yes, of course.
We could say our older employees. Yeah. But yeah, so what I'm hearing you say is that, you're seeing these long-term COVID effects actually arise over a broad spectrum of generational aspects, as well as, well, I'm not sure what else there is, but anybody can be hit by long-term COVID. And so it does have some long-term implications for work. And you've already then alluded to the fact that sometimes it's not the end result is not to end work, but instead, well, what alternatives exist to work? And then, looking at, the various factors like wage and hours and all that kind of stuff that are all part of the process. But again, sometimes we need to do what we need to do because of a medical condition. It's not because the employer is doing this to an employee, which sometimes they feel that's the way it is. But no, it's just that if you can't do your usual job, then we have to look how else do we keep you employed. And that adjustment in hours and wages and all that kind of thing. Yeah. Okay, so it's alive and well, unfortunately, and here we keep going on. So 2025, we'll see what the year has to bring. Yeah. Okay, so another thing that comes up a lot, Felicia, that you and I talk about frequently, is just helping our districts, helping our people who work in HR and risk management understand, the scope and breadth of the workers' compensation case. And you and I both have had some recent situations that directly speak to this topic. And so, yeah, you said the workers' comp case now. And so I'll start with you, Felicia. What's give a highlight of one of your recent examples that we talked about.
With we always use real cases, but obviously this is anonymous. We had a school district who had a custodian who had a very complicated and litigated two claims, an orthopedic claim and a psychiatric claim. And they were in litigation and preparing for trial. There had been discussion of what we call a full and final settlement, which would have required a voluntary signed resignation, but the employee was not interested in resigning. They wanted to continue their employment. And so then there was discussion. The case settled basically what we call on the courthouse steps right before a trial was scheduled to happen. And it settled for a small permanent disability award for the accepted orthopedic claim. And then the psych claim was what we call dismissed or a take nothing, which means you, just like what it sounds like, you don't get any benefits from your settlement. And then the trial was avoided, and the attorney felt that this was the best outcome for the district. Since the employee still worked for the district HR department called and said to me, well, now what do we do? The employee is still off work with notes that don't seem to have any end in sight per a non-industrial condition, and they're frequently absent from their position. From the workers' comp standpoint, I answered the question that all of the doctors in the workers' comp claim had released that employee to full duty work without any temporary or permanent restrictions. And so there wasn't anything really to meet with on that particular issue, but I know you and I had some conversations that there is more to that story, right? To the question of what do we do now if we can't have an IPM because there's no notes or work restrictions on the industrial side? What about these notes we have on the non-industrial side? And what about the, we don't have a person who is able to do the job, right?
Right. Yeah. And so, in that kind of case, and I have a similar example to share, is that, so yes, you might get the workers' comp findings for workers' compensation guidelines, which we know are very specific, they're very structured administratively and legislatively. But that doesn't negate the existence of a medical condition that led to the filing to begin with. Whether the claim was denied or accepted, even if it was accepted, but still found to have 0% long-term disability, is still a condition. That doesn't mean that there may not be some impact on work functioning. And so it's, even when you get a finding like that, it's still very important to engage the employee in an interactive process to say, okay, here's what it is on the workers' comp side of things for work-related injuries, but how are you impacted in your day-to-day functioning in the job? And this then comes under the Americans with Disabilities Act and the Fair Employment Housing Act, because as an employer, if you have knowledge of a medical condition, here's what it's your obligation, your responsibility to evaluate. Are there any lingering effects? Is there any impact or impairment of functioning in the job? And that's both related, but yet separate from the workers' compensation guidelines. And so don't just write it off, because those could come back to haunt you. Yeah. And so I just went through a recent situation too, where, it's like a 5-6 year, term employee with a particular district, and she was working in a special job as, a regular job classification. But in the last couple of years was starting to make some, complaints about people and her coworkers, and even the teacher in the classroom weren't doing their job the way she thought they were doing their job. Okay, that's another story as far as an employee weighing in about how somebody else should be doing their job. But it did lead to what we subsequently learned in the IPM that was held back in September, was that she had been afforded an accommodation at the local site level, which Human Resources didn't know anything about. So as we sort of really delved into things, one is that because of the nature of the accommodation request, again, not shared with Human Resources, but kept at the local district level, she was actually permitted an early departure from work, but with no adjustment in hours or distribution of workflow. And so she was still being paid the same rate as all of her coworkers, and yet not being there, the full contractual job assignment. Instead, what they were doing was shortening her morning and afternoon breaks, required by another law, and shortening her lunch breaks in order to make up for the 45 minutes early departure. Well, that's violation of yet another labor and wage law in California. You are obligated for a 15-minute break after 2 hours of work and 30-minute break after 4 hours of work. That does not work into making adjustments for accommodation. That's another law. Okay, we don't have the right to do that. So what went on is that then we sort of deduced, because there was an investigation that went on, and there was all kinds of other worksite adjustments made to the working team because they were at odds. And so the employee ultimately presented a 12-page document in August, and then saw her doctor. Her doctor took her off of work because of work-related stress. She immediately filed the claim for job-related stress, and so we're trying to understand what's contributed to this and so forth. And so as time has gone on, she was taken off of work. Um, Again, the whole accommodation about early departure came to HR's attention. We connected that with the findings, and so it's like, maybe coworkers were a little bothered that this employee was being left to leave work early, and then they were left to deal with the aftermath of that. So it's like, okay, that will contribute to workplace tensions, no doubt about it. Then she was seen by QME in October, and of course, it took a while to get the findings. The QME determined that because it was job-related stress that she was claiming, that, as you know, and hopefully most of our listeners know, is that it requires that job-related stress must be contributed or caused by 51% of the contributing factors overall. And the QME found that while it was noted that she had a pre-existing condition of behavioral elements that contributed to stress, only 4% was considered work causation. Well, the immediate conclusion was that she can do her job. Okay, so what's the problem? Go back to work. And the employee thought that too, and it's like, well, no, wait a minute. And so in November, she requested to come back to work. We didn't have the report from the QME, but it was just based on what we were told by a different claims administrator. And it's like, well, wait a minute. You had a doctor that took you off of work. To come back to work, you have to have a doctor releasing you to return to work. We don't have that. And so even though she was told that, we ended up meeting for an IPM and right before Christmas, and she still didn't provide any documentation. It's like, help us understand what just because the QME says that your claim does not meet the threshold for workers' compensation, doesn't negate the existence of your underlying behavioral health issue. And
right.
So it was like, okay, let's separate these out, but let's connect them too. And so what was decided here for workers' comp purposes, again, didn't indicate that she didn't have a condition. In fact, it was 4% contribution, but she did have a history of pre-existing. And so, and then she wanted to come back to work, but then she had no supporting documentation to say she was released to come back to work. And so we just met again and sort of worked through that. And it took a few of us to this discussion in the IPM to say, okay, are we all understanding that, yes, she has a condition, but at this point, there are no symptomology that's affecting her performance in the workplace. And so we finally got to that agreement after everybody's trying to interpret this not so well-worded document. But does that mean that the employer just puts her back in the workplace where she left last time, that she's been into? It might be a good idea to move her to a different location if that meets business needs, not as accommodation, but just good practical sense. Why put her back into an environment where she already had difficulty? Although she had a difficulty in 2 locations, so that was questionable. So a lot of coaching, a lot of education to the employee went on about what this all means. Now, that doesn't, what happens is that she's another underlying condition for which she was originally provided the accommodation, but she still didn't provide medical documentation on. And so, well, what's the medical purpose for why you have to leave? And so she sort of told us, I said, well, your employer has the right to explore how can your treatments be rendered differently so you're not missing work, because right now, if you're missing work, you're not working the contractual hours, you're not performing all of the essential functions, and there may be no other work opportunity available. So we were able to put her into a temporary assignment, which does match her current time frame for working, but it's only temporary. And so now we're pursuing medical information from this other doctor. So it gets complicated.
Really complicated, right?
Yeah. And we have to have several minds. Okay, is this what you understand? Is this what makes sense to you? And employee, where are you coming from? And part of it was a lot of education to her. As far as, not understanding how the U.S. system worked and so forth. So anyway, engage in the interactive process as your first step, folks, because it will gain you all kinds of information. And like you said, Felicia, rather than, the whole fighting, does this qualify under the ADA or FEHA or whatever, that actually was sort of let go back before 2008 when we had the amendments to the ADA. Don't quabble over that. Get to the point. Somebody needs an accommodation. Is it short-term, long-term, and what can we do? Let's keep and not Now,
I have seen what you're talking about in your example a few times at the district where they could have accommodated them in their current position, but because that's the position that they filed the psych claim against either stress going on with colleagues or stress going on with supervisors, they put them in a different place just to let's just start over. That's not really in the medical restrictions. That's just what you were talking about, best practice, that, well, we've already had problems here. Let's see if we can move you. I think I've seen them move them to different sites, and I've seen them move them to different departments where they can still do the job that they're trained for.
right. And so it's really getting down to, does it make good business sense?
Right.
Yeah, for us and for them, and not that we need the medical, but not to get so mired in the medical, and then to say, okay, what can we do? And we already know that many employers, many programs have the right to move people around anyway. So why not do it if it makes good sense? Now, if it happens again, no, that's another story, and that's another protocol. So we'll leave it at that for now. Okay. Great. Okay, so now planning ahead, who's on, who's off, and managing the July 1 rollover. So, Lisa, I'd like you to start with this because we did talk about this back in, I think, July or August, and checklist we'll share with people.
Right. Well, and I love the baseball reference because I think this does take a team of risk, HR, and payroll. Those three people or that three departments need to work as a team on looking at the end of the school year. We talked about looking at the beginning of the school year. Now we're talking about the end of the school year will be upon us in May or June, and it comes up quickly. So from a work comp perspective, we want to look at all the employees that are off work on workers' comp injuries. You also want to look at non-industrial injuries, and maybe I'll let you tackle that. But for workers' comp employees, you want to talk to the claims team that's handling their file to make sure you have the most updated work status and talk to them about where they're at with their leave, the claims team, so they know what's happening and when they're going to run out of leave, if that's going to be before July 1 rollover or after. And if they can work towards with the nurse case manager and the claims team on getting them to return to work or to some kind of a permanent and stationary status so we can get some permanent work restrictions. And if we can get the permanent work restrictions, we can do an IPM to discuss whether or not the district is able to accommodate them or not in their current position or in an alternative position. But in order to even get there, payroll has to tell HR and risk when are they running out of leave. Whenever employees call me with whether they're with their union rep or not, the first thing I ask them, the first thing I say is that we're self-insured and we pay for our own claims, and the money that pays for salaries and pays for raises also pays for workers' comp claims. It's the same, comes out of the budget. And I also state, where are you at with your leave? Well, so many employees tell me I have no idea. And I said, well, you're running through things. So do you have sick leave left? Do you have vacation left? Do you have 100 days left? Where are you? And when are you running out of leave? Well, they have no idea. Well, I feel that employees should always know that they're going to be running out of leave and when that's going to happen, because it helps them understand and plan and work with their doctor. And it's also a real motivator to try to engage in your medical treatment and get yourself stronger and better so that you can try to get back to work. I just think we kind of float around and then we come right up to the end of the school year, because it's not really July 1, because it's the end of the school year, unless you're 12-month, that we really start looking. And then they clock over and they have new sick, new vacation, new 100 days again with a new bank. And so we really should be looking at it now, kind of in preparation and getting ready for that.
Right, yeah. Definitely, I agree that employees should know where they stand with their use of sick leave and then also the 100 days. And so for those of you employers out there right now who wait till they're about ready to enter the 39-month or have already, and you haven't done the IPM yet, that's really late in the game as far as I'm concerned, because again, that knowledge of a medical condition under the ADA is really key to when you want to start implementing your efforts. And again, using that that first IPM, if anything, for educational purposes and making sure everybody's on the same page and that the employee clearly understands what the process involves. And so I just had not too long ago an employee that was a workers' comp case, but he had also had several injuries over the course of time, and so there was overlapping recovery, and was put back to work in temporary work, but was he really working, temporary modified work? So again, more injuries. I've seen this happen several times. Additional injuries occur because they're not really working in a capacity that's really safe for them. But this also goes back to what doctors say, and the doctors
Right.
put them back. But really, is that and we're not to question the doctor's thing, but we also need to exercise good business sense. Like, really, is that really safe for the employee? And so with this one employee, I don't think he's been to work since 2022. Still on the payroll, and because he had enough sick leave, but also he managed to push it to the point of where he became eligible to return to work temporarily. It went off again.
Got a new bank.
Yeah. And so, I've got several cases going on right now is that people have already been off of work, sometimes not 2 or 3 years, and they're still on the payroll, and no return to work and no return to work in sight, and yet they're still on the payroll. So this is where you want to take a look at all these things and take a look at what's the pattern been, because as those of you who have worked with me out there is that that I start drawing in FMLA. Because FMLA also has a threshold. And so while it may not necessarily apply directly, we can use their criteria to help guide us here. Somebody can't work 2/3 of their assigned job in 1 year. They don't qualify for job protection. That means that they're medically unable to work sufficiently to retain the job.
Okay. One of the things that I see so much when I talk to employees, and I've also sat through a few IPMs where you've been moderating, where the employees are stunned. They have no idea what will happen if they're leave-ins before the July 1 rollover. They just assume that they're going to be taken care of because they got hurt at work for an infinite period of time, and don't understand that they actually could be put on 39-month and be replaced and lose their health benefits. And sometimes in the IPM, it's a shock, and that should not ever happen. That should not happen. Should not be shocked. You should know exactly what's happening and what could happen if you run out of leave before you reach the July 1 rollover.
And I'll just share with you, Felicia, having done this work for many times and working very closely with the EEOC in past cases, is that kind of I should say, that lack of communication between employee and employer that leads to those situations are the exact ingredients for complications and litigation.
Right.
So that's what's going to make your employee angry, upset, not feel cared for, and that's where they're more likely to file some act or workers' comp one side, employment the other, another side, and that's a greater burden for the employer, greater cost for the employer.
Right.
So how you treat and care for your employees going through these medical conditions has a huge plays a huge factor in how that case may resolve and the potential litigation factors. So why words to the wise. Yeah. Okay. And so the last question that we have, and I just changed my screen, so I've got to go back and look for it. Okay, there we go. Yeah. So when accommodation requests are denied, what happens next, and what does EEOC plan to do about it? And so this gets all into employees will disclose their disability but not claim accommodation. So what's that about, Felicia?
Yeah, I was fascinated by this article. I was also surprised. They were saying there was nearly 3 in 4 workers who responded to this survey said that who requested an accommodation and had their request denied by their employer. That's kind of where this started from. And then nearly 9 out of 10 workers said that they had formally disclosed their disability at work. So a majority. But 75% of those refrained from requesting any form of workplace accommodation. Some said that they feared that their supervisor would view the request negatively. And then Deloitte did this survey. They surveyed like 10,000 employees with a disability or a chronic medical condition or a neurodivergent condition. And they found that accommodations remain a real issue in the workplace. 11% of the workers resisted requesting accommodation because they felt they would negatively impact their job. And many of them because they'd have a negative impact at a previous job. So they knew what might happen. Many who requested accommodation found that their requests were denied. 3 out of 4 of the times had at least one of their requests denied. And the common reasons given were accommodation was too costly, too difficult to implement the accommodation request, or unreasonable, quote, unquote. Many of those requests were assistive technology. That was a lot of the things that they'd requested, and coaching and training up for some positions that they could do, but they needed a little bit of coaching to do them. And the most common request was, we know what it was working from home sometimes or hybrid, scheduling adjustments, kind of goes back to our first article, and private space access. And so they said that they saw negative perceptions from their employer regarding requesting accommodations. Some of the accommodations were denied. A lot of them found that they couldn't attend, I thought this was very interesting, work events or meetings because of access issues and other, I'll say, non-inclusive behavior. And so one of the things that after the survey that some of the conclusions were that disability inclusion was really important and that needed to be a visible leadership priority. In order to show those actions were being taken. So I thought, and there was about 10% of the employees stated that they had experienced some harassment. This is of the 10,000 that were surveyed, and about 7% some bullying by supervisors and coworkers over their disabilities and their requests for accommodation for disabilities. So it was unfortunate. And this is a recent article. It just came out in January. So obviously we have a lot of work to do still.
Yeah. I mean, this raises all kinds of things, given my history in this field, that I'll share a couple of things is that, first of all, when the whole Americans with Disabilities Act and the California Fair Employment Housing Act were evolving in the 80s, that there was a lot of work done on disability etiquette. How do you engage with employees? Like, back then the focus was like on people who use wheelchairs, people who had visual impairments or hearing impairment. How do you engage with them appropriately, respectively, with etiquette? And so I was part of that training endeavor, and so just helping people, helping educate people about how to view people as people first, the disability is second. It's like putting race first before being the person, or putting religion first before the person. And so put the person first always. And then say, they just have different means of accessing or doing whatever. This is different. Okay, nothing wrong about it, So a lot of disability advocate went on then, and I think maybe it's a time to revisit that whole thing. So that's one thing that comes up into my mind. The other thing I'll share from the Job Accommodation Network, this whole idea about too costly. Most job accommodations, by the JANS data, is less than $100. Okay, so this is shifting the method or manner with no assistive devices, but the predominance of accommodations are $500 or less. Okay, and so there may be some that go much more, but and there's a criteria that as far as is this administrative, is this a system in nature, or is this more engineering, environmental things that then become more costly, like putting in a accessible restroom. making sure all the doors are automatic opening and closures. Well, that's something that's got to be factored into the budget thing. So that's a little bit different, but they have a requirement to do that under the ADA anyway, under public access, and then for accommodations. So these are all factors that come into play, but most of them are $500 or less. That whole thing. And then if it's unreasonable, well, why? What's unreasonable about it? And so
Right.
the word's readily achievable and effective. And so I have been in situations of where, okay, that's going to take a while, so that's not going to be done right away, but okay, can you factor this into your budget in the next year? Well, yeah. Okay, so you need to know that, yes, you can be accommodated, but for now, we're going to have, this is a bigger cost factor. Bigger, construction, engineering kind of thing that needs to be taken into consideration. So there are many layers of this. I used to be very involved in building access issues, and so I used to know that very well. And so that's where I know all of this comes into play. So what I want to encourage people is that, if you're having difficulty, be curious, be courageous, say, I'm having difficulty, because otherwise it could show up in your performance.
Right.
That's the thing. And that's one thing I try to encourage employers. If somebody's performing differently than what they were, have a conversation, because it could be that there's some medical condition driving that shift in performance that can be accommodated. And on that note, too, is that whenever you do have performance, use the word deficits, although it's a little bit strong, but whenever you have performance deficits, but now a medical condition is involved, you still proceed with your performance practice, but you may defer the outcome until you look at what kinds of reasonable accommodation can be implemented that will actually help restore performance back to full functioning. So those type of performance disciplinary practices, that if there's medical involved, you got to do the IPM concurrently and try to address accommodations that will
work on both of the issues, right? Side by side.
Yeah. Because if we can bring the performance back up, guess what? There's no performance issues anymore.
Right.
So Felicia, we've had some interesting hot topics this week. Long COVID, settling the workers' comp case, but what next? So look at how does that medical condition potentially impact the workplace. Also planning ahead, being aware of who's on, who's off, and trying to avoid that inadvertent rollover, because we just what do they call it? Tending the mind. The verbiage is there, and then also we want to promote a work environment that people who have medical conditions that develop, that they know they can continue working safely, but being considered for differences. And again, we've all had them. I know I have. I know you have, Felicia. We all have them at some point, and for unexpected factors. So what other parting words do you have for our listeners today?
I just wanted to give a big shout out to San Diego County office, the Hill, as we call it, where I work. I did have a medical condition. This was several years ago now. I've had my position for a long time. This was maybe 10 years ago. And you're right, I had temporary work restrictions where I couldn't drive and I couldn't come to the office, and I couldn't do my job in the way that I normally do. I needed to work from home for a period of time. And they were just great, completely cooperative. I had no fears, and I continued on. I did have to work a little differently, right? Because I do a lot of in-person meetings and trainings, and they completely worked with me. So I just wanted to give a big shout out for them.
Okay. Good example of a great employer then. And that's what really shapes the model and attitude for how San Diego County operates. So if you're not aware of it, please embrace it, and more to come in 2025. That's for sure. So, Lisa, thank you again for being part of this journey into hot topics when medical conditions impact work. And you're such a valuable resource, and love your contributions.
Yeah. Oh, I had a lot of fun. I really enjoy it. I learn a lot when I'm preparing for it. So
yeah, absolutely. So and that's part of our goal, folks, is that we get asked lots of questions. We confer a lot about different situations, and we created this podcast as a forum to pass on to you information that's important to know, and guiding you in how you deal with your employees at your local workspace. So thank you again for joining us, and we will see you next month. A couple quick announcements. Again, our recording will go back out to everybody who is pre-registered. And so do share it with your colleagues and invite them to register for our next one coming up in February. We're generally the second Wednesday of the month, but the first this year threw us off a little bit. And then two, I want to let people know that I will be, I've got some travel myself, being in a different time zone, exciting, yet it will limit my availability for interactive meetings, not to eliminate them, but it will be on requests only. And so keep that in mind, requests only from February 6th through the 13th, and again from March 1st through the 14th. So pretty close, but again, be monitoring email, all that kind of stuff, be responding to questions, but actual IPMs will be limited and by request only. Okay, so I have backup and in case we need to do something just because of the different time zones. So just want to give you everybody a quick heads up. Okay, so thank you again all. Join us next month. Hot topics in the workplace. Bye-bye.
Bye, everyone.